This is the In Focus podcast from The Hindu.
Hello and welcome to another episode of the Hindu's In Focus podcast. I'm Zubaida Hamid, your host for today. The Surrogacy Regulation Act was passed in 2021, but over 2 years later, it continues to be mired in some amount of confusion and ongoing cases at the Supreme Court. Brought in to ban commercial surrogacy, it allows only for altruistic surrogacy and only under certain conditions in the country, and aims to regulate surrogacy clinics that are part of the huge infertility health sector in India. Last month, the central government brought in a modification to the surrogacy rules. It allowed married couples to use donor eggs or donor sperms to avail of surrogacy. This overturned the government's own earlier rules that had banned the use of donor gametes. The rule now states that if one person of the intending couple has a medical complication that does not allow them to use their own gametes, then a donor gamete can be used for the baby. However, a genetic link is still a must. The other partner must provide the egg or sperm, as the case may be. This means that divorced and widowed women have to use their own eggs, and the law also bars single unmarried women, those in live in relationships, and those in queer relationships from its ambit, a provision that is currently being challenged in the Supreme Court by an unmarried woman. How will the new amendment change things for prospective parents? How can donor gametes be obtained when their sale is banned and the donation is strictly regulated? Has the Act met its goal of regulating surrogacy clinics and protecting surrogate rights? We delve into these questions and more with Professor Prabha Koteeswaran, a professor of law and social justice at King's College London. Good afternoon, Professor Prabha Koteeswaran, and welcome to the Hindus in Focus podcast.
Thank you very much.
Professor, the Centre has now amended the surrogacy rules, allowing for married couples to use donor eggs or donor sperms for a baby. In case one person has a medical complication that does not allow them to use their own gametes, they can use these donor gametes. Could you explain to us how this amendment in the surrogacy law came about?
Yes, thanks. So, as we know, assisted reproductive technologies in India are regulated now by the Assisted Reproductive Technology Regulation Act of 2021. And surrogacy, which is a form of assisted reproductive technology, is regulated by the Surrogacy Regulation Act of 2021. Now, the Surrogacy Regulation Act essentially tells us under what conditions couples can actually avail of surrogacy. So, one cannot have genetic surrogacy, which is where a surrogate donates her gametes to the child. Instead, the only thing that's allowed in India is gestational surrogacy. Further, as we know, also it has to be altruistic and not commercial. But in terms of who can access surrogacy, the Surrogacy Regulation Act specifies that the intending couple must have a medical indication. So, what we have in the Surrogacy Regulation Act, there are rules under the Act which were passed in 2022, which essentially has a whole list under Rule 14 of the Surrogacy Regulation Act rules, where it talks about various conditions where the intending mother either does not have a uterus or is not able to carry the child to term because of a range of medical conditions. So, or, has had repeated miscarriages and so on. So what happened was, you would normally have to go to a district medical board and get certified that the couple are suffering from a medical indication before one can proceed to find a surrogate and so on. Now, in addition to that, under the rules, there is a form which is signed by the surrogate. The surrogate essentially commits to various conditions, and one of the statements in that form says that she agrees to the fact that donor oocytes may be used with the husband's sperm in order to create the embryo. So, what happened in March 2023 was that the government introduced a change to this form, essentially modifying the language to say that both gametes had to come from the intending couple. Now, this posed a lot of problems because if you remember, these laws came into force in January 2022. So there had been a good 15 months during which intending couples had initiated their surrogacy procedure. So, all of a sudden, where one partner was unable to donate gametes but had already created embryos, they were in a slight quandary, wondering whether they could go ahead with the surrogacy because of this new rule that was introduced in March 2023. So what we have a public interest litigation pending before the Supreme Court challenging both acts. And as part of that litigation, several applications were made to the Supreme Court, essentially on part of women who had medical conditions. In particular, these were women who Justice Nagaratna, whose applications she entertained, they had a congenital disorder called the MRK syndrome, which essentially meant that they couldn't carry the child to term and nor could they donate oocytes. So Justice Nagaratna essentially wanted these women to go back to the district medical board to find out whether they could contribute oocytes. And once the reports came back saying that they couldn't, then what Justice Nagaratna did was issue an order in October 2023, essentially staying the new amendment to the rules, which essentially required that both partners had to contribute gametes. So she looked at the whole, the form and substance of the Surrogacy Act. She looked at the form and substance of the rules and found that actually Rule 14 is, and the entire act is formulated in a way which is empathetic to the condition of intending mothers. So she held that this particular rule could not trump Rule 14 of the surrogacy rules. So once she issued this order, there were many more applications that came up before the Supreme Court. And here there were women with various conditions. It could be cancer, it could be various other chronic conditions where they could not contribute gametes. And I think in the meantime, the government decided that this particular requirement was not proving to be very realistic. So they've amended this rule. And so a lot of these petitions now have been dismissed by the Supreme Court. And the court has now moved on to the main issues in the litigation.
The government basically did away with the fact that the intending couple both have to contribute their own gametes in order to avail of surrogacy. And they said that essentially only one person of the intending couple can contribute the gamete, and therefore then they can go ahead with the surrogacy, correct?
Yes, that's right.
But they still insist upon a genetic connection. One person of the intending couple has to have a genetic connection with the baby, which means that divorced or widowed women who are opting for surrogacy as per the law have to use their own eggs. Is this criterion justified?
Yeah, I think this is very complicated. It's a complicated answer because fundamentally the conditions under which you can access assisted reproductive technologies is, obviously a policy question, and different countries around the world, have very varied criteria. Some are far stricter than the Indian laws, some are more lenient than the Indian laws. So it's a question of, every government deciding how they want to structure access to these ARTs. It doesn't necessarily make them right, but what has happened traditionally, if we look at the history of these two laws, because in the 90s and the 2000s, clearly a lot of couples came to India for transnational commercial surrogacy. And at that point, because we didn't have really any rules governing questions such as, genetic linkage, what we often found was that consulates in India, foreign consulates in India, when they were trying to issue documentation to the baby before they left the country, would often insist on a genetic link with at least one of the parents, because that was also a pathway to, deciding questions of nationality and citizenship. And further, the Law Commission of India in 2008, when they recommended altruistic surrogacy, also suggested that there should be some genetic link between the child and the parents. So I guess what I'm trying to say is that I'm not surprised that there is this kind of requirement. But then, of course, the question really is, how are we constraining reproductive autonomy? I guess the way that the court might be looking at this is to really think about the relationship between ART and adoption. So if in fact, an intending couple have no relationship with the baby, or if, an intending mother doesn't have a genetic relationship, I think there are those who would argue that why not default to adoption? So this is uh, a question of reproductive autonomy. And this could have been actually rendered even more complicated if the marriage equality litigation had been successful, because under those circumstances, deciding this question would have been very urgent, the question of the genetic link. But I think this is something which is a substantive question of law. It goes to the heart of women's reproductive autonomy. Under what conditions you don't want to have a baby, and under what conditions you should have a right to have your baby. So there are uh, there are writ petitions pending before the Supreme Court filed by single women, and I believe that this will be taken up in the arguments before the court.
That's an interesting argument about the fact that if there is no genetic link, then the argument could be extended to the fact that the couple could just adopt rather than avail of surrogacy. And I'm sure we're going to hear more about that as the Supreme Court hears this case. Going back to donor gametes a little bit, Professor. In 2021, when both the ART and Surrogacy Acts were passed, we talked about donor gametes in our podcast at that point, when we looked at the fact that the ART Act bans the sale of gametes, eggs or sperm. Is there any clarification now on how donor gametes can be obtained and how the practice works?
Yeah, I think those are quite difficult questions to answer because we don't really have enough data yet on how it's working. We have some preliminary data that's coming out. So clearly, just in terms of the law, there have been a series of forms which have been introduced in February 2023 as part of the rules to the acts, which lay out that the intending couple have to file an affidavit. It has to be sworn before, a metropolitan magistrate or a judicial magistrate or a notary public or an executive magistrate to essentially say that, we've produced these embryos or these gametes are our own. And they have to file this affidavit saying that they want to either transfer the gamete within India, the embryo within India, or the gametes or embryos outside of India. This is where it's your own biomaterial. Now, of course, and there is some evidence that many couples are following this procedure. If you look at the responses of the government in the litigation, you can see that there is a whole listing of couples who have asked for this kind of permission. There are some interesting patterns there, but the question is every intending couple really filing this information or getting this this approval? So this is something that we actually don't know if it's happening in reality or not. And under the law, also clinics, holding clinics and receiving clinics have to file similar affidavits. But what we can see is, if you recollect, also the two acts have very stringent restrictions on donation of gametes. So women can donate their oocytes only once in their lifetime. Only 7 oocytes can be picked up at any given point. Similarly, for men, the sperm can be used only for one commissioning couple, not for more. So there is generally there are many ways in which the supply of gametes has been restricted, which would suggest that there is a shortfall in the gametes available for IVF cycles. Now, last year, one of quite a prominent gynecologist ran a survey on the impact of the new laws on the clinical practice of ART clinics. And what he found was that actually, because about 35 to 40% of IVF cycles in India are donor cycles, the question of donor gametes and their short supply is having, quite a dramatic effect on the practice of ARTs in the country. So actually, a very large percentage, about 3/4 of the medical practitioners who responded to the survey there said that they did not think that the new laws were making ARTs more feasible, more affordable, or more accessible. And they predicted that actually the costs of every cycle now would go up by 125%. So there is some emerging evidence where both, first of all, doctors are not clear exactly about how donor cycles can now be managed, because the registration of the various clinics and the banks under the acts are not complete yet. So many have held off donor cycles till they are registered properly under the acts. And then, even if they were registered, to carry on ART in the face of this kind of gamete shortage is suggesting that the costs of every IVF cycle will actually go up. And also, the way the acts are regulating the sector suggests that because the registration fees are quite high, that smaller clinics would probably not be able to take up a lot of these ART practices. So what that really means is then there's also reduced medical facilities for commissioning couples and intending couples. And then this would also, therefore, increase the cost, as well as the fact that there is now much more paperwork and bureaucracies to negotiate, especially if you're undertaking a surrogacy.
Is there anything in the acts that talks about how gametes could be donated, in the sense that is there anything that specifies who a donor could be?
Yes, absolutely. There are very clear guidance on who can be an egg donor, who can be a sperm donor. There are age criteria that are set out in the law. So, for example, an egg donor can be only between the ages of 23 and 35, and a surrogate can only be between the ages of 25 and 35 and be ever married with a child. Now, those restrictions obviously are there for a reason, and one could quibble about, uh, the 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 age, the other restrictions that are there. But I think what is really made gamete donation problematic is the requirement that they be altruistic. So now, in the case of sperm donation, obviously it's less onerous for men to donate sperm, whereas for women, actually, it's a very elaborate process where they have to undergo, at least 10 days of hormone stimulation. They need to be scanned in between to make sure that the follicles, the egg follicles, are being developed. And finally, when the time comes for actually pickup of the eggs, they have to be under general anesthesia to actually, aspirate the eggs and so on. So when you're talking about quite a substantial level of effort to be put in by the women, and the law mandates that they not be paid at all, that obviously would disincentivize women from coming forth to donate eggs, which will then reduce the supply of gametes. So there's a lot of good provisions in the law, but I think it seems to be that these very strict restrictions on gamete donation, the fact that it has to be altruistic, the fact that it can be once in a lifetime, the number of eggs that there's, and the fact that you can't share between couples, all of this suggests that the supply of gametes would have gone down considerably.
When a couple is availing of surrogacy, does that mean that then the surrogate who is going to carry the child cannot be an egg donor herself?
Yes, exactly. So that is the distinction between genetic and gestational surrogacy. And India, we do not allow genetic surrogacy. And I think also in most parts of the world, you do not really see that anymore. Some of the initial cases, very high profile cases that became sensational in the US, for instance, involved genetic surrogacy. But by and large now, it's on, and certainly in India, only gestational surrogacy is allowed, where the surrogate only births the baby and gestates the baby, but does not contribute her oocytes to the baby.
We spoke a little earlier about the law. While it allows divorced and widowed women to opt for surrogacy, bars those in live in relationships and those in queer relationships from availing of surrogacy. During the course of arguments in the Supreme Court, which is, as you said, hearing multiple cases at this point, the court has asked whether an unmarried woman having a child would go against the norms of Indian society, how can this affect the legitimacy of the child, etc. Why was this provision, do you think, brought into the law?
The provision regarding only married and divorced.
Only married, divorced, or
Yeah.
widowed. Why does the necessity have to be there to have been married once, even if you're not anymore?
Yeah, I mean, I guess this is how we, clearly the law reflects societal values around, how a heteropatriarchal family has to look. And we believe that despite the incredible possibilities of ARTs, that only a very small sliver of people should be allowed to access ARTs. So that is deeply problematic, obviously, because as you said, it excludes a very vast number of Indian citizens from actually realizing the right to have a family and to, enjoy the benefits and the love that comes from forming a family. And we have happen to have access to these scientific techniques, but they're excluded from it. So, of course, this is a matter of challenge before the Supreme Court. And when there will be substantive arguments on these provisions, I suspect that there will, some of these arguments on the right to reproductive autonomy will be put forward. Just on the very limited point around legitimacy, I think it was interesting that it came up in the hearings because actually, even under the two acts, under Section 8 of the Surrogacy Regulation Act and Section 21 of the ART Regulation Act, it's very clear that a child born out of either surrogacy or ARTs would be deemed to be a biological child. So, in terms of legitimacy, I don't think the laws anticipate that this would be an issue, and therefore, and I think generally across family law, there is the sense that children should not be penalized for the actions of the adults, and therefore they should be treated as biological children. The question more is about in it's more about women's reproductive autonomy and what kind of families we want to see in Indian society. And there is, of course, a lot of evidence from other countries to show that, a range of family forms actually do not compromise the well-being of the child, whether the parents are LGBTQIA or whether they're born out of surrogacy. So there's a lot of evidence to show that actually one could raise happy children in a diverse set of family forms. So I think this is again a question that has to be tested on constitutional grounds before the court.
Quickly moving on to what we again spoke a little earlier about, ma'am, you said that so the rules have come in, the forms have come in, and under the acts, boards, all the states have to form boards to regulate infertility clinics. It's been 2 years now. Do we know how this is being implemented? Have all the states formed boards? Have all the clinics come under these boards, etc.?
Yes, actually, so very interestingly, with these two laws, I think there was a lot of the government was very keen to set up rules and get all the various bodies set up under the two acts. So, certainly the National ART and Surrogacy Board has been set up, and in the various states, 27 states and union territories have notified the creation of these boards, and they are all in different levels of formation in the various states. As well, the ART and surrogacy registry has been set up, and many of the appropriate authorities have also been set up. So I think on the part of the state, these bodies have been set up at a decent speed, I would suspect, compared to other laws where it might take years for these bodies to be set up. So there is a will on the part of the government to actually regulate the sector. Now, in terms of registration of the clinics and the banks, under the acts, that's taken a bit longer. So if you look at the ART and surrogacy portal, for instance, we find that there are 5,261 clinics that have applied for registration, but only 405 have actually received their registration certificates. Similarly, with surrogacy clinics, 958 have applied, but only 171 have received their registration. And with banks, again, there's 1,300 odd banks that have applied for registration, but only a tenth of them have gotten registered. So clearly, I think there is some lag here in terms of the registration. But it's clear that the state, especially given the large number of notifications that have come under the rules, that the government is keen to enforce these laws.
And do you think overall, ma'am, that this has helped protect the rights of women who would otherwise have opted for commercial surrogacy?
That's very hard to actually answer that question because I think we are in a period of stabilization where the acts have been passed, the various bodies are being set up. And I think there is still a fair bit of lack of clarity on the part of the medical community in terms of the provisions of the two acts. And I think depending on how risk averse a clinic might be, they're holding off on certain procedures and going ahead with others while they figure out what various provisions of the laws mean. And more importantly, what are the levels of implementation of the acts? So that is something that we still have to test and see. But of course, this has not been helped by the fact that the two acts are being challenged before the Supreme Court. Because obviously everyone will be waiting and watching because quite key provisions of the acts are now being challenged before the courts. Now, on the ground, it's hard to collect empirical data on exactly what is happening in terms of the number of surrogacy transactions or in terms of the donor cycles and so on. It's very hard to know. But given that there is a huge demand and there are a very large number of infertile couples in India, one can confidently say that because of the demand for such services and now the new restrictions of the acts on how these transactions can be performed, one would suspect that actually the law is likely not being followed on the ground. To what extent it is being followed is something that one needs to investigate. But given the very high threshold for registration, for intimation to the state, and procuring approvals from the state, and because the machinery is not fully operational yet, chances are that clinics and various stakeholders are testing the boundaries of the laws and undertaking transactions which are probably not strictly legal, but because there is no implementation yet, they're going ahead with it. So I think once the constitutionality of the various provisions is settled before the Supreme Court, I think then we will see clinics going ahead with some level of certainty, and hopefully also the implementation bodies will give us a sense of how they are going to implement these laws. Because if you recollect, the punishments under the laws are very high, and they're very stringent laws, both of them. But obviously, the stringency of the law has to be tested in reality, and I think this is something that will unfold over the next couple of years. So it is too soon to say.
Thank you so much for speaking to us today, Professor Prabha.
Thanks a lot. Bye.
In Focus will be back soon with analysis of the biggest news issues. In the meantime, you can find our podcast on Spotify, Apple Podcasts, Stitcher, and other platforms. Just search for In Focus by The Hindu. We'll see you soon.